Good morning, Your Honors. May it please the Court. My name is Amy Dilday. I'm from McCumber Daniels, and I represent the defendants below. Judge Valenti, I would like to reserve 5 minutes for rebuttal, if I could.
You got it.
To add a claim for punitive damages against corporate defendants, Section 429.297 requires a plaintiff to proffer evidence to show a reasonable basis for recovery of those punitive damages. Because a plaintiff proffered no evidence of knowing corporate participation in employee misconduct, no evidence of a corporate officer ratifying or condoning employee misconduct, or no evidence of corporate gross negligence that contributed to plaintiff's injuries, the trial court erred in granting plaintiff's motion for leave to amend to add a claim of punitive damages against the corporate defendants, G.V. Largo, Lar Largo, and senior management advisors.
Okay, Ms. Dilday, let's talk about the standard of review, because this is unusual. You're up here, not unusual, you're up here for cert.
Yes.
Okay, and under a cert standard, it's a little bit different from a direct appeal.
Yes.
So, and I know you and the other side have some disagreement as to what is our scope of review. He's taking the position that because it's up here on a writ of certiorari, that all that it is, you need to make sure that the proper procedures were followed.
Yes.
And taking the position that the judge below followed the proper procedure by having an evidentiary hearing, gathered whatever evidence and whatever conclusion that your client received the procedural, they followed the procedural requirements.
Yes.
You're taking the opposite view. So are you asking us that it's well within our review power to delve into the exact evidence and to reweigh the evidence to determine whether or not that there's sufficient evidence for the court to conclude that there was enough for punitive damages?
Absolutely not.
Okay,
Judge
help me
Kazan.
out with that then.
Okay. It's true that under the Globe newspaper cases and any cases that follow, they say when a court is reviewing on certiorari review, a trial court's granting the leave to amend to add punitive damages, the only thing that this court can look at, or any appellate court can look at, is whether the procedures were followed to meet the requirements to plead those punitive damages. You cannot go into the evidence if those procedures were followed and determine whether the evidence was sufficient to prove the claim of punitive damages or to merit the claim, or as long as there is evidence that is required under the procedure, as long as the procedure is met to make the evidentiary showing in the first place, there's no reweighing of that evidence. Was it enough? Was it not enough? Do they get to amend? Here, the argument is that that procedure was not met. There was no evidence whatsoever. The statute specifically...
Well, let me ask you a question. They did have a proffer attached to the complaint.
Oh,
the
yes.
affidavit of the expert and
Yes.
depositions and things like that. The complaint had
Yes.
quite a bit of language in it. Explain to me what was inadequate in the attached proffer as a matter of law that the court could not have allowed the amendment at that point in time.
The proffer was very extensive, Your Honor. They had their expert, they had depositions, they had corporate documents. They did not have any evidence that would support any of the elements that the statute requires.
But aren't we then getting right back full circle into looking at the substantive weighing of the evidence, which we're not supposed to do in cert? And I guess that's a segue into the question that was raised in my mind. I think I understand your argument that, look, this was a lack of evidence to the point where we had a failure of a procedure.
Yes.
Can you articulate any kind of a limiting principle or any kind of a legal rule that this court could announce, could craft, could make, that would clearly and definitively define those cases where there was just a complete failure of evidence that arises to a procedural error, so that we're not straying beyond where we're supposed to in certiorari proceedings?
Oh, absolutely, Your Honor. The third DCA in Coronado condo case came up with that legal analysis, and basically it was, if you don't have any evidence whatsoever of corporate conduct, the procedure has not been met. Here, there is no evidence. We've got all kinds of evidence that...
But you made reference to the Coronado case. So let's look at the Coronado. Isn't it true, though, that the Coronado case was so factually, in that case, the court said there was no allegations whatsoever regarding the association's active participation, knowing participation, consent regarding the misconduct. This is different here. Wasn't there allegation, if you look at the amended complaint that was filed and the affidavits that were submitted before the court and the proffer of testimony, that the companies that were in a direct, like in the next stage higher and higher, they were aware directly because of either the payment schedule regarding review of the law. Isn't that a little bit different from the Coronado case?
There were, the Coronado case looked not just at the allegations, but at the record evidence. The Coronado case says, we see no evidence in the record. And the proffer, as you know, can either be something that the plaintiff brings forward, or it can be what's already in the record that the court can review. I'm lost my train of thought.
Take your time, because you made reference, you're asked the question, what type of procedure, what type of rule, and you made reference to the Coronado case, so they're the ones that establish
Yes.
what would be guided by the courts.
Yes.
And then you made a comment about the Coronado case, basically found that, and I was trying to bring to your attention what the Coronado case factor is a little bit different, because there's really deficiency in that case regarding the allegations, versus here, as I review the facts and what was presented, it appeared that they've alleged in this case that direct correlation between the corporate structure and one of its employees.
I disagree, Your Honor, that the Coronado case says there's deficiency in the allegations. Again, the Coronado case clearly showed that they looked at a record, they looked at evidence. Allegations are insufficient to prove punitive damages. You look at the Santo Bank versus Rigo case. You look at this court, Cypress Aviation versus Belia
Can I
case.
interrupt, because you made a statement, and I don't mean to interrupt you, but at this stage, they don't need to prove. Isn't the statute says that, and I quote, let's see the language, that no claim for punitive damages shall be permitted unless there is a reasonable showing by evidence on the record or proffered by the claimant, which would provide a reasonable basis for recovery. It doesn't say to prove.
Correct.
Proving is further down in terms of the levels. I want to make sure that we're talking about the same thing.
Correct.
All right.
Yes, and I agree with that principle, absolutely, Your Honor. They don't need to prove it at this point. They've tried to claim that we're trying to make them prove it, and we're not. But there has to be some evidence. They have proffered absolutely no evidence of corporate misconduct. The Fourth DCA in the Holmes case said the purpose of a proffer is to demonstrate real error, not imaginary error.
Well, didn't they allege inadequate procedures? There was a pattern of inadequate treatment, and the policies didn't address it. The corporate knew about it and let this guy linger with all these infections and everything else.
Yes, Judge, they absolutely alleged all of that.
And you're saying that's not enough?
They did not give you any evidence of it. In fact, they said, sure, senior management advisors, they provided the procedures, but there's no evidence whatsoever that any of the procedures were inadequate. They say, they allege that maybe there was overstaffing. I think there were some allegations, or maybe the nurse complaint even said, well, when you look at this, sometimes it's because of overstaffing. That was the extent of it. There was no evidence. Nobody got down to the numbers. Nobody said there was understaffing in this facility. There is no evidence.
And you're saying they can't use that as raising a presumption that knowledge would be imputed somehow?
It can't. There has to be something actual before the court to say, okay, there is an actual reasonable basis to find punitive damages. Now, we may go, let's say, for instance, that they did proffer numbers for staffing. We may go to court later and argue that and prove or not prove that those numbers were sufficient staffing, but they didn't even get to this level here. In fact, in trial court, although they had alleged that the procedures were inadequate in their pleadings, the counsel admitted, well, we don't really have any evidence here that there were inadequate procedures, and in fact, no procedures were entered into evidence. There was absolutely no evidence, and that is a problem, that the procedural requirements were not met because no evidence of any corporate conduct. As to Largo, the evidence...
So Coronado was your best case?
Coronado...
Because Coronado, there was no proffer whatsoever.
But record evidence. Again, the court looked at record evidence. Coronado, there's 3 third DCA cases really on this issue now, and Coronado being the lead one that we use. There's an earlier one written in 2010, the the cruise case, the Caribbean cruise case, where they found a steward was knocking on people's doors and he was drunk that night or whatever. People had called security and security never responded. And in that case, the court specifically said, and it was a third DCA, although the steward's conduct may have been punitive, there was no evidence that the corporation, that any officer, any director of the corporation also ratified, condoned,
And the third
participated
DCA
in that.
issued a writ of certiorari in that case?
In Coronado, I don't think it was a certiorari. I think it was, yeah, there are very few certiorari cases, although the third DCA did issue the case that I sent up as a supplemental authority, the SCI funeral home case, which also was on certiorari, whether the body that was exchanged, whether there was corporate punitive damages on that case. And the third DCA, again, found no evidence of corporate conduct. Here, Lar-Largo, all the evidence going to Lar-Largo is that they were the management company in 2009, that Prescott, the administrator, dealt with them. That's it. What corporate conduct is there against Lar-Largo?
What was presented before the court, I thought, and correct me if I'm wrong, I thought there was a proffer provided that the directors and the higher up the corporate ladder had direct supervision of the entity below, and that the entity below, there's allegations that were provided that there was really, one of the allegations, no documentation. Apparently several times he's been to the hospital back, no record of that. That was some of the allegations that were submitted, and that one of them indicated an employee, that part of the bonus structure, and again, they're supervised by the higher corporate ladder. They determined basically, okay, people coming in, the bonus is determined. You don't think that's sufficient? I mean, these are just a couple of things I just pulled up based on the proffer.
Yes.
I'll agree with you. Coronado, there was really nothing that was submitted in that case. But for this one, what was presented before the court, allegations of absolutely no record keeping whatsoever. And there's an affidavit from an expert saying that's outrageous conduct. And
Sure.
that's condoned by the higher up.
But what's the evidence of the condonation? In any plaintiff's case, in any case, the union case, the logging case, the cases that the plaintiff used to say condonation, there's always some evidence that they talked to a supervisor and the supervisor said, don't worry about it, it's okay.
So the fact that somebody, if there's evidence that somebody is in direct supervisory control of an individual, perhaps control is a little bit strong, but just somebody, and the allegations is that this is part of the structure, you're taking the position that there has to be something more?
There has to be evidence, Your Honor. That's what there needs to be. And it cannot just be, I'm sorry.
Oh, no, I'm sorry. When you say evidence, if somebody condones or somebody condones an action, you don't think that's sufficient?
If there's evidence of that there was condoning and that it was corporate condoning. Here we've got evidence that a man named Mosher supervised Mr. Prescott, the administrator. We have to see, was Mosher a director? Was he a controlling member of the corporation? It has to be at that level. I think the reason that the case law is so confused on this, the reason that the courts are confused is because the standard today is heightened by the 1999 Tort Reform Act. They added this new corporate language where there had to be actual evidence that is subsections 2 and 3 in any punitive damages statute, including the one that we're talking about today, of knowing active participation. And prior to the Tort Reform Act, the way you brought a corporate into a punitive damages analysis was by vicarious liability under the Schropp versus Crown Motor Car case. And in that case, they would allow for punitive damages if an employee had punitive misconduct and if the corporation did any other negligence. It could be ordinary negligence. But then in 1999, in the Tort Reform Act, the legislature changed that, heightened the needing of showing a corporate.
But the Globe case was in 1995, but it's never been overruled or modified or clarified to take account for your argument about the 1999 tort reform.
Sure. Oh, and that standard that Globe set out hasn't changed. There has to be a procedural, it's procedural only that you can review. But the procedure required is what has changed, and it's really just the 3rd District that's first starting to get this. And admittedly, they're getting this in civil cases that are unrelated to nursing home, but
you
they're...
are at your 5 minutes, but you can keep going.
Oh, am I?
I got you off track. You were talking about the 3rd
No,
District paving the way to have a
Let me just say this. The evidence in this case is that the trial court was still using the prior vicarious liability Schropp analysis, which allowed any general negligence by a corporation, whether or not it was punitive, unlike what the statute requires today, because the court said on page 36, well, the employees are agents of the corporation, and that just does not meet the statutory procedural requirements. Again, the trial court said on page 24 of the transcript, ordinary negligence was enough. He needed to find only ordinary negligence by the corporation. And Judge Kazuma, I think that goes to your question. Ordinary negligence is not enough. Even if there's corporate evidence that they were negligent, that the supervising was negligent, the statute requires more now. It requires more. It requires punitive conduct, gross negligence.
And the statute, and I guess you're proceeding under, if you look at subset B, it basically says that in order for the officers, director, or managers, or other legal entity either condoned, ratified, or consented to such conduct.
We need evidence that there was an individual corporate officer or manager who did that, and that evidence just does not exist in this case. I will reserve whatever I have.
You got 3 minutes.
Thank you, Judge.
May it please the Court, Isaac Ruiz-Cruz on behalf of the Respondent. This case really begins and ends with the trial court's order, which is in the appendix to the petition for certiorari at tab A.
I mean, let's get to the heart. Tell us about Coronado, why we shouldn't take the approach that your opponent is saying they took in a Coronado with this procedural versus substantive distinction, that the procedural now can involve some substance, as I understand the argument.
Sure. Well, first of all, I think it's a thinly masked argument to try to get to the sufficiency of the evidence. And when you look at Coronado, the statement that was made by the defense in response to Judge Kazam's question, which is, in Coronado, there really wasn't a proffer. There really wasn't any record evidence. I think Your Honor also pointed that out. And if you look at the Coronado case, there was no proffer, and there was no evidence. Instead, it was a proposed third amended complaint and a motion for leave to add a claim for punitive damages. So it fits squarely into that line of cases that come after Globe that say if there's a deficiency in the procedure because you didn't file a proffer, because you didn't file a motion, or there's cases such as the court took the matter under advisement but allowed the punitive damages amendment to go forward anyhow. In those instances, I do believe that certiorari is appropriate. But case after case, beginning with Globe, which is why I was going to the trial court's order in the first instance, if the trial court has made a determination that there was a reasonable showing that would provide a reasonable basis for recovery of punitive damages, which is the standard that's required under the statute, and if in fact there was a motion made prior to the amendment being permitted, and if there was a proffer that was filed for the court to consider prior to this particular order, and there doesn't even need to be a hearing. We know that much from...
Are there any cases out there since Globe by the Supreme Court of Florida that talk about changing the standard of cert vis-a-vis the tort reform of 1999?
No, in fact, the Florida Supreme Court has time and time again affirmed what it said in Globe, and twice, when the most recent opinion that I found was Williams versus Oken from 2011, and in particular there, and that's at 62 Southern 3rd 1129, the Florida Supreme Court said certiorari review is appropriate to determine whether a court has conducted the evidentiary inquiry required by section 768.72, but not so broad as to encompass review of the sufficiency of the evidence considered in that inquiry.
That's the same quote they had from Globe.
That's exactly right. So they continue to affirm that principle as recently as a few years ago. Now, candidly, there has been a change in the statute. 429 is now different. The nursing home statute also was amended last year, and one of the provisions that was affected was the punitive damages provision, and now there's a heightened evidentiary requirement. There actually has to be an evidentiary hearing. The status of the law at the time that this particular case was decided, there isn't even a need to have an evidentiary hearing at the punitive damages phase.
And kind of dovetailing with that, would you concede that you could have a situation where there was a properly filed motion for leave to amend, proposed amended complaint with request for punitive damages, and a proffer, so that takes us outside of Coronado, but where the proffer could be so wanting, just have nothing to do with punitive damages, picture what you will, where that showing is so deficient that it could rise to the level of an outright procedural failure that would be subject to certiorari review.
Well, whether or not I agree with that hypothetical, this court has to decide the case that's before it and the record that's before it. And if we get to the evidentiary question,
I'm not suggesting that is this case, but I'm trying to understand the legal line, if you will, between this procedural substantive distinction for purposes of deciding whether or not this is even appropriate
Sure.
for certiorari review.
And
Could you have that kind of failure?
well, here's what I think the principle is coming from that underlines the defense's argument, and that is that the entire principle here is the protection of financial net worth discovery.
Of course.
And the court found that there's a substantive right there. So then now we're talking about due process rights. And so the question becomes, if it's so failing, that proffer, that it's so defective, does it raise to the level of a due process concern such that the court can now act? It's sort of like a fundamental error type of analysis. I think it'd be very similar to that. But quite frankly, this isn't the case in which this court needs to elaborate that particular principle. Because even if this court were to delve into the evidence that was presented, this is like hundreds of cases before, and I've had lots to this court. Frankly, I was surprised we had an oral argument in this case, because each and every instance in which there's been a cert petition like this court has either granted a motion to dismiss the appeal or just denied the writ of certiorari. But since we're here on the oral argument, if we want to look at the evidence that was presented, there were several statements that were made with respect to the corporate entities, saying that the evidence was insufficient for the trial court to make the findings that it did. I don't think it's appropriate for the court to second guess it, but let's look at some of that, because one of the entities was GV Largo, Inc. That's actually the licensee. And I know from trying to come to this court and argue that consulting pharmacists should be held liable for acts in nursing homes and being shot down and told, no, the nursing home licensee has a non-delegable duty of care, and that would amount to both actual and punitive damages liability. Well, here we have the actual licensee, and we've attached as part of the proffer the license itself, the application for licensure. There was a statement made that we actually didn't put any policies and procedures into the proffer. She said into evidence, and I know what she meant, because we're not actually putting anything into evidence. But in the proffer at 6I, we actually put the policies and procedures into place. So under this court's long-established law, which was the Badger Acquisition versus Johnson case, where I lost on consulting pharmacy, there's a non-delegable duty for the nursing home licensee and also for an ALF licensee. We know that's true, too, under NME versus Rudick, which we cited in our briefs. Then we get to what's the other companies that we got punitive damages leave for. Another was the management company, the actual company that managed this particular assisted living facility. Now we know, how do we know that? Because in the proffer, tab 6G, we actually attach the management agreement itself. So we know what the terms of that management agreement were. And if you look at those terms, it includes the day-to-day operation of this particular facility. Now, when you look at, well, is that enough? This court has found that it is enough, actually, after a trial, to be simply the consultant to a nursing home. That was the Peyton Healthcare Campbell case that this court decided in 1986. Now, the law has not changed with respect to that aspect of a management company being involved in the operation of an assisted living facility or a nursing home. There were simply necessary forms and policies and procedures being provided, and consultation. They weren't even running the day-to-day operations. Here we have much more than that. If one looks at the management agreement, as the trial court did, you'll find that they're actually running the day-to-day operations of the home. Now, defense counsel pointed out that the administrator said he reported to someone else who was responsible for the day-to-day activities. And that particular individual was this Mosher guy, as she put it. And she said that if we could show that the Mosher guy was somehow a director, then we could actually establish, at this point, amendment for leave as to that company, which is the third entity, Senior Management Advisors. And if the court looks, we actually have attached, it's 6M of the proffer that was available to the trial court. This is the website of Senior Management Advisors. And Mr. Moshner appears as the director of operations of that entity. So there was, in fact, evidence that was put forward in the form of a proffer that showed that the individual that the administrator said he reported to on all day-to-day operations was, in fact, a director of the Senior Management Advisors entity. So this is just some of what was in the proffer. I'm obviously not going to go through all the hundreds of pages that were involved, but there was evidence, ample evidence, to support the court at this stage, which is not under the new heightened burden under the new statute, at this stage finding that there was a reasonable showing.
Yeah, it just has to be a reasonable basis, not ample evidence. So.
That's right. And now, of course, we have to show clear and convincing evidence, and that wasn't the standard at the time. And what's interesting is the court understood this. And I know that this trial court has actually heard thousands of these particular types of motions. And if you look at F in the appendix, Judge Rondolino mentioned, and this is on page 34 of the transcript, their proffer is directed to the active and knowing participation conduct of the corporation, which is the precise language of the statute that the defendants are now complaining about. They said the trial court somehow was applying the old corporate negligence standard.
I think she was referencing that you're giving a label and a nomenclature, but there's no connection between the label and the act of misconduct. I think that's what she's saying is lacking.
That may very well be. She was citing the quotations from the trial court to try to evidence that he maybe misunderstood and was applying the old Schropp versus Crown Eurocar standard. And here, it's clear he was applying the appropriate statutory standard, understood what it was, and in fact, once he made the finding, getting back to where I started with the order, where he found the court has determined and finds the plaintiff has made a reasonable showing that would provide a reasonable basis for recovery of punitive damages against 3 entities, the 3 that I just went through. But then what's more interesting is the court actually determined that the plaintiff failed to make a reasonable showing and provide a reasonable basis for recovery as to another entity. So he denied the motion to amend to add a claim for punitive damages as to a 4th entity. Clearly shows that the trial court followed the procedures that were required. This is not so flagrant a case with respect to a due process violation. Frankly, I don't think there is a due process violation. There is a meritorious argument. There was evidence or a proffer of evidence made that was sufficient under the statute, but this court doesn't need to take this case to try to carve out an exception or lay out a rule of due process that would permit this type of review. That quite frankly, this is an easy case for the court to follow what the Supreme Court said in Globe versus King. Now, twice this court in the early years departed from Globe versus King before Globe even came out. Beverly versus Maggiacomo and Walmart versus Corden. And in both instances, this court had found Judge Patterson in the Maggiacomo case and Chief Judge Blue in the Corden case. In both instances, the defendants had argued that there wasn't enough presented in the form of a proffer with respect to corporate employer misconduct. And in both instances, this court agreed by certiorari review and found that there was not enough in the proffer. And in both instances, the cases went to the Supreme Court of Florida, and the court found and quashed the DCA's orders, finding that in accordance with Globe, there is no certiorari review. And so here again, the trial court followed all the procedures, we followed all of the procedures, and it would be inappropriate to expand certiorari review to include this case. Thank you, Your Honors.
Thank you. All right, Ms. Dilday, you've got 3 minutes.
Thank you, Your Honor. I would like to first of all clarify exactly what we are not talking about here today. We are not talking about the 2014 version of the statute that has been amended and requires a hearing and other things for punitive damages. We're talking about the statute that applies to this case. We are not talking about that there was a change in the standard of review for certiorari for this court. That has not changed. We are talking that the standard for what is a reasonable basis, what is a showing of reasonable basis, what that procedural requirement is, has changed in the punitive damages statutes, and that's changed and is applicable to this case today because it changed back in 1999. The Despain Court in the Fifth Circuit in 2005, although they were still using the Schropp vicarious liability analysis, in several footnotes they discussed in detail that the standard has changed, that it's different, that different evidence will be required to plead punitive damages against corporate defendants going forward.
You know, Ms. Dilday, and I know where you're going at, but I guess if you look at the transcript and the questions that Judge Rondolino spoke with the lawyers, he came to a conclusion that he found that there was management, the upper management was involved, the participation day-to-day activity. This is what he came from. You guys don't like it. And that's where the danger is, that now you're asking us to do what Globe specifically said. And Globe said that what you're trying to do, Globe is inviting this court to take a further step to review the sufficiency of the evidence considered by a trial judge here. And that's where I think you're going, under the guise of procedure. And that concerns me. I think based on what was presented before Judge Rondolino, he had a whole bunch of proffer before him. You may not like the result, but he explained his position that he does, based on what was presented, that he could see that there was a direct day-to-day management of the entity below. So I'm concerned about that.
I know I'm out of time. May I respond just very
I'll give you a minute.
briefly? Thank you, Your Honor. Even Isaac mentioned the evidence that they had. Sure, they put the policies and procedures in evidence, but where is the misconduct by the corporations? Where is it? There was no evidence of it. They have the management agreement, but where is the evidence? They agreed to abide by the day-to-day operations, but there is no showing that just because the employees maybe did not follow those policies, that was because the corporation agreed to that or condoned it. In Williams versus Tandem Healthcare, and again, this is not a cert case, the first DCA, though, found that even though the corporate procedures weren't followed, that the resident had followed, they failed to ensure that there was even adequate staffing. It did not rise to the level of punitive damages because it requires more than just ordinary negligence on the part of the corporation. Thank you, Your Honor.
Thank you. Very well argued. Thank you.
Thank you both.
You ready for one? Okay. We'll go to the last case when these folks have given you the room to come down. The Carlson and Six Limited Partnership.